Thank you very much.
Good afternoon, Honorable Justices. My name is Sylvia Truckee, and I appear alongside my co-counsel, Ethan Golba, on behalf of the appellants, Mr. and Mrs. Sinclair. The appellant will advance two submissions for the court today. First, that two Ontario contracts are connected with the foreign dispute, satisfying Vendretta's fourth presumptive connecting factor, as clarified by LaPointe. These are the Centurion Card Member Agreement and the Amex Canada Carry International contract for the water taxi booking. Second, the invoked contracts withstand rebuttal, satisfying jurisdiction simpliciter. I will address the first submission. My co-counsel will address the second. Before I proceed, would the court like a brief summary of the facts?
Well, thank you, Counsel.
I will now introduce the first submission. The appeal requires an examination of the two-stage test for determining jurisdiction simpliciter established in club resorts and Vendretta. At the first stage, the plaintiff must demonstrate one of four presumptive connecting factors that demonstrate a real and substantial connection between the dispute and the forum. At the second stage, the defendant may rebut the presumption of jurisdiction by demonstrating a weak connection between the dispute and the forum, or under the doctrine forum non-convenience, by demonstrating another forum is more appropriate to hear the litigation. At issue in this submission is the first stage of the Vendretta test, specifically whether the fourth presumptive connecting factor has been established. This states that a contract connected with the dispute was made in Ontario. LaPointe clarifies the undertaking of the first stage of the Vendretta test and adds that the presumption of jurisdiction first requires the court to identify the nucleus of the claim, and then assess whether the nucleus of the claim is connected with a contract made in the forum.
If we look at the contract, who are the parties to that contract that's at issue before us today?
Justice, the parties involved in the Centurion Card Member Agreement are Amex Canada and Mr. Sinclair.
Not Venezia Turismo, is that correct?
Correct, Justice. However, paragraph 32 of LaPointe states that the alleged tortfeasors, in this case the Italian defendants, need not be parties to the contract in order to establish Vendretta's fourth presumptive connecting factor. Paragraph 44 of LaPointe adds that the events that give rise to the claim need only flow from the relationships made by the contract. So although the Italian defendants are not parties on the Centurion Card Member Agreement, the Centurion Card Member Agreement structured a chain of arrangements that led to these relationships with the Italian defendants, whereby the water taxi accident ensued. Kaiko Global Inc. held that the test for jurisdiction simpliciter is a question of mixed fact and law, reviewable under a standard of palpable and overriding error, except where extricable error of law arises, whereby the correct standard would be correctness. The court must defer to the motion judge who, at the preliminary stage, correctly used the good arguable case standard to assess whether the factual assertions of the pleadings establish Vendretta's fourth presumptive connecting factor. While we presume our friends may—
This court, I don't think, can easily defer to the good arguable case standard established by the motions judge, simply because it was not subsequently engaged by any following court. It was not engaged by the decisions of the Court of Appeal, nor was it engaged in by the decisions of the court below us, the Supreme Court of Canada. How can this court now, on appeal, defer to a standard that was not used by any of the two courts below us?
Justice, the good arguable case standard reflects decades of Ontario jurisprudence that is practical and fair.
Which is not the same as saying that it's a binding authority or perhaps even persuasive. What submission do you have before this court for why we should adopt that framework?
At the preliminary jurisdictional stage, the evidence on the motion is very limited, and the courts must not devolve into a trial on the merits of the claim, whereby focusing on objective facts that would demonstrate a real substantial connection between the dispute and the forum with a contract. And so the good arguable case standard must be used to avoid this type of mini trial on the merits of the pleadings. While we presume our friends may recharacterize the core issue on appeal as one of contract formation, which is a question of law reviewable under a standard of correctness, this court is not asked to make a final or absolute decision regarding contract formation. The appeal instead concerns whether the dispute sufficiently connected to Ontario, and whether jurisdiction simpliciter is satisfied. Although the dispute may appear as a tort occurring solely in Italy, thereby warranting Italian jurisdiction, such a conclusion would ignore the nucleus analysis required under LaPointe. From the pleadings, the correct characterization of the nucleus of the claim is the negligent provision and coordination of travel services flowing from the Centurion card member agreement and the Amex Carry International contract for the water taxi booking. Turning to the Centurion card member agreement, the alleged negligence flows from the performance of obligations undertaken by this contract, including travel agent and concierge services and the coordination of third-party service providers. Evidence of formation of the Centurion card member agreement is based on Amex Canada's pleading at paragraph 31, which states, where Amex Canada admitted the Centurion card member agreement was made in Ontario, expressly relying on the Sinclair's statement of claim to ground jurisdiction over the Italian defendants.
Counsel, isn't the ultimate act of negligence that caused damage to the Sinclairs what happened in Italy, and the corollary negligence arguments that flow back up the chain of contract, wouldn't those be better resolved in Italy as well?
Justice, it is the appellant's submission that this chain of negligence is connected with the Centurion card member agreement and the Amex Carry International contract. The Centurion card member agreement established a chain of arrangements that ultimately led to the water taxi accident whereby the Italian defendants are engaged. To explain a little bit more about this chain of arrangements, the Centurion card member agreement required Amex Canada to provide concierge and travel agent services to Mr. Sinclair. This included the water taxi service.
But the provision of those services were provided by Italian residents. The driver of the boat was Italian. The employer of the driver was Italian. The dispatch service that connected that employer with the customer was Italian, and Italy is not a country devoid of the rule of law. Why cannot the Sinclairs bring this very same dispute before an Italian court that should have jurisdiction instead of bringing it in Ontario?
Justice, the Centurion card member agreement set in motion a chain of arrangements leading to this accident. To continue off of the chain that I've already established, to fulfill these obligations, Amex Canada engaged Carry International, a third-party provider with contractual duty to perform transportation services, and hired competent personnel to perform transportation services.
Hey, counsel, we understand that there is a connection. That's not a dispute. But wouldn't it be more appropriate for this to be sued in Italy, seeing as the driver was Italian, the tort happened in Italy, the company was one that was in Italy, everything happened in Italy, so why should this be pursued here?
Justice, the final stage in this chain of arrangements that connects the Centurion card member agreement and the Amex Carry International contract with this nucleus of the claim, the negligent provision of travel services, Carry International, bound by its contractual duties, engaged local service providers in Venice, whereby the Italian defendants are engaged. As Venezia Turismo called on Mr. Dordet, the water taxi driver, who is employed by Venezia Limousine, to collect the Sinclairs, after which the accident ensued. The Italian defendants are jointly and severally liable because the interrelated torts of negligently engaging incompetent persons to perform transportation services and the negligent performance of transportation services are connected with these contracts and flow from these contracts, satisfying Vendretto's fourth presumptive connecting factor.
Counsel, if we disagree with you and if we decide to not allow the appeal, will the Sinclairs still have right to pursue a tort claim in Italy?
Yes, Justice. If this court grounds jurisdiction in Italian courts, the Sinclairs can pursue litigation in Italian courts, but this would be extremely unfair. If the court fails to accept the appellant's submission, this would lead to the recharacterization of future jurisdiction motions, whereby the key issue is not determining jurisdiction simpliciter, but is instead assessing with finality evidence of contract formation. This would lead to true jurisdictional overreach, as jurisdiction motions would become mini trials on the merits of the claim, which are typically preliminary at the jurisdictional stage. May I request a brief indulgence to close?
Yes.
In closing, the motion judge correctly found a good arguable case based on the pleadings that Vendretto's fourth presumptive connecting factor was established with the Centurion card member agreement and the Amex Carry International contract for the water taxi booking. The appellant adds that these two contracts reflect the nucleus of the claim, which transforms Sinclair from a tort localized in Italy to a chain of negligence flowing from the relationships made by Ontario contracts, grounding Ontario jurisdiction through a real and substantial connection. Barring any further questions, my co-counsel will deliver the final submission. Thank you, Justices.
Thank you very much, Ms. Chair.
Good afternoon, Honorable Justices. My name is Ethan Golba, and I will be addressing the second submission as counsel for the appellants, Mr. and Mrs. Sinclair. The second submission addresses one key issue. The crucial requirement of rebutting the presumption of jurisdiction has undeniably not been met. The framework governing this issue is not in dispute. Once a presumptive connecting factor is established, the onus shifts to the defendant to rebut that presumption by showing that the factor does not, in substance, point to a real and substantial connection between the forum, the dispute, and the defendant. The first stage concerns the existence of that connection, while the second stage concerns the strength of that connection. The rebuttal inquiry is therefore, at its core, contextual and substantive. It is not formalistic. The majority accepted, for the purposes of this analysis, that the Centurion Card Member Agreement between Mr. Sinclair and Amex Canada was formed in Ontario, and that the events giving rise to the claim flowed from this agreement. That finding is crucial. The majority nonetheless concluded that the presumption of jurisdiction was rebutted on the basis that the connection to Ontario was weak, relying primarily on the fact that the accident occurred in Italy and involved Italian defendants. With respect, that reasoning misapplies the rebuttal stage. The situs of the tort and the foreign status of the defendants are not on their own sufficient to rebut jurisdiction. Rebuttal requires a showing that the contractual connection relied upon does not meaningfully ground a real and a substantive connection to the forum.
Counsel, I agree with your submission completely. If Sinclair were to walk into the door of Venezia Turismo on his own and book the service, that would be a very different situation from the facts that are before us, where it goes through a series of intermediate steps. How do you address that distinction?
Yes, Justice, good question. For our case at bar here, according to LaPointe, the defendant need not be party to the initial contract. The tortfeasor need not be party to the initial contract to come under the purview of that contract. Although the Italian defendants were not party to the initial card member agreement, the events that occurred did flow from that agreement.
Not being party to the contract deals with the presumption, and we agree with you that we are past the presumption stage. How does that factor into the rebuttal stage?
That factors into the rebuttal stage as in the second stage, the rebuttal stage, the onus shifts to the defendant to prove that the presumption has been rebutted.
Isn't that exactly what they did in the lower courts before the Supreme Court of Canada?
The appellant's position is that the defendants did not put forward enough evidence to properly rebut the presumption of jurisdiction, and that the connection here is not so that the jurisdiction was rebutted. The question at rebuttal is not whether Ontario is the best or even the most natural form but whether the existing connection is so weak as to lack legitimacy. We anticipate that our friends on the respondent will argue that jurisdiction must be assessed from the perspective of each defendant, and that the Italian defendants neither carried on business in Ontario nor could reasonably expect to be sued there, pointing to the foreign location of the business and the Italian nature of their operations.
Can you help me understand the standard of review that this court should be applying in considering the issue of the rebuttal test?
Yes, Justice.
Where does that lie on the spectrum of ex facto law or determination of law in terms of the determinations made by the trial level judge on those issues?
Yes, Justice. According to paragraph 41, the test here, or the application of the test for jurisdiction simpliciter, is a question of mixed fact and law, reviewable for palpable and overriding error.
So then we would owe some deference to the trial judge's decision on that issue.
Justice, regardless of such, the appellant's position stays the same, that the presumption of jurisdiction has not been properly rebutted here. The question is not whether the Italian defendants operated in Ontario, but whether the Ontario contract grounding jurisdiction meaningfully connects the dispute to the forum. Jurisdiction does not turn on a defendant's subjective expectations, especially when the defendants are alleged to have been engaged through Ontario-based contractual framework. The error in the majority's analysis flows from its characterization of the contract, or of the dispute. The majority treats this case as a boating accident in Venice, and seldom looks outside this scope. This narrow framing fails to account for the claims pleaded as a whole. The statement of claim alleges not only negligent engagement of the water taxi, but also negligent engagement of service providers and negligent operation of the water taxi, all through a service chain initiated in Ontario. These alleged torts are pleaded as interconnected, and they are said to flow directly from the contractual relationship created by the initial Ontario agreement.
So as I mentioned to your co-counsel, we're not disputing the fact that there is a connection. But as we saw at the Supreme Court, they did establish there was a connection, but that connection is tenuous. How do you respond directly to that?
Yes, Justice. Once the dispute is properly characterized, the strength of the Ontario connection becomes clear. Mr. Sinclair accessed the concierge service pursuant to the Ontario card member agreement. The water taxi reservation flowed directly from that service. The Italian defendants engaged within that service chain and are alleged to have owed duties of care arising from it.
But the Italian defendants did not solicit or go out and find the Sinclairs, so why do they owe that duty?
As the Ontario contracts pleaded in this case serve to establish proximity amongst all defendants, and again are alleged to owe duties of care in negligence, including against the Italian defendants. This is not a tenuous connection, it's not an incidental connection. This is a real...
If we use your framework of proximity, you'll agree with me that there is a significant amount of distance between the St. Clairs and the ultimate driver of the boat. Like I mentioned, the St. Clairs didn't speak to the driver of the boat. They have an agreement with American Express, which then referred them to a third-party booking service, which then referred them to a dispatch service, which then connected to the employer of the driver, who then sent the driver to speak with the St. Clairs. If we use the framework of proximity, those parties are not close at all.
Yes, Justice, in location they may not be close at all. However, these all still flowed from the same contract. By isolating the accident from the broader pleaded negligence, the majority effectively collapses the rebuttal stage into a matter of strict geography. Such an approach undercuts the rebuttal stage itself, making it artificially difficult to sustain jurisdiction, even where, as we've said, a presumptive connecting factor exists. The rebuttal stage is meant to assess whether the Ontario connection is real and sufficiently strong. It does not reframe the dispute in the narrowest possible terms. We also anticipate that our friends will argue that focusing on this broader service chain risks jurisdictional overreach, effectively allowing Ontario courts to assume jurisdiction over any foreign service provider wherever a Canadian uses a credit card travel service abroad. This should be made clear. This case does not involve a traveler casually swiping a credit card overseas. It involves reliance. Reliance on an Ontario concierge service that marketed a safe and a seamless travel experience and allegedly engaged foreign service providers negligently. Holding jurisdiction in these circumstances does not create overreach. It is a faithful application of the Van Breda framework. These considerations here that we have, as the majority relies on the nationality of the defendants, the location of the accident, and the assertion that the Italian defendants could not reasonably expect to be sued in Ontario, are not particularly relevant to jurisdiction simpliciter. Jurisdiction, again, does not turn on a defendant's subjective expectations, nor should it. In sum, as co-counsel established, the motion judge was correct in their finding of a good arguable case in which the fourth presumptive factor was met. Following that, the burden lay on the Italian defendants to demonstrate that the Ontario connection was too weak to ground jurisdiction. On the pleadings accepted as true, they did not meet that burden. The rebuttal stage does not allow the court to disregard the contractual foundation of the dispute. The rebuttal stage does not allow the court to narrow the claims to their final, to their physical, to their tragic manifestation. For those reasons, we respectfully ask this court to allow the appeal, set aside the stay of action, and restore the motion judge's decision, permitting Ontario courts to assume jurisdiction over the Italian defendants. Barring any further questions, that concludes the appellant submissions. Thank you,
Thank you,
Justices.
Mr. Goldbach. Thank you.
Good afternoon, Honorable Justices of the Supreme Court of UW Waterloo. My name is Tanishika Kumar, and I appear alongside my co-counsel, Faith Sajid Kumar, on behalf of the respondents, Venezia Turismo. The respondents will make two submissions before this court. I'll address the first, and my co-counsel will address the second. First, the fourth presumptive connecting factor is not made out because no contract connected to this dispute was real and was made in Ontario. Second, even if the court were to find that a presumptive connecting factor exists, the presumption of the jurisdiction is rebutted, as Ontario lacks a real and substantial connection to this claim. The respondents will now make our first submission. Honorable Justices, Venbretta makes clear that the jurisdiction simpliciter does not arise from the mere existence of a contract formed in the forum. Rather, the fourth presumptive connecting factor is deliberately confined to the contract that is connected with the dispute itself, as the Supreme Court of Canada explains at paragraphs 90 of Venbretta and reiterates at paragraphs 52 to 58 of St. Clair. The limitation is central to the Venbretta framework. It reflects the court's concern with preventing jurisdictional overreach and with promoting order, fairness, and predictability in private international law.
Counsel, does the application of the Venbretta framework by a trial level court that's trying to determine whether or not jurisdiction exists, does that involve making factual determinations?
Counsel, can you reiterate, Justice, can you reiterate when you say factual determinations?
Yes, determinations like things like where the contract was formed, who the parties to the contract were, what the terms of the contract may have been. Are those sorts of things called upon of a motions court judge in applying the Venbretta framework appropriately in your submission?
Justice, in terms of finding of fact and mixed fact of law that are owed to deference and may only be distributed for culpable and overriding error. However, whether a contract is legally connected to the dispute engages a correctness review of the governing legal standard. The respondents rely on error and principle in the application of the overall Venbretta framework. Here, our friends from the other side rely on two alleged contracts. First, the American Express Canada card member agreement, and second, the water taxi reservation made through Amex's concierge service. Neither is capable of grounding jurisdiction. First, turning to the card member agreement.
The reason your friends rely on that particular constellation of contracts is because they have made adequate submissions before this court that essentially says, but for those contracts, the St. Clairs would not suffer harm. How do you respond to your friends?
In response to my friends, the only Ontario connection to this dispute is the administrative booking step, while the alleged negligence, defendants, and harm all rooted back to Italy. Even if an Ontario contract exists.
But the harm followed is the point I'm trying to impress upon you, is that the harm followed the booking. No booking, no harm.
The booking does not necessarily conclude to the fact that it connects to the overall harm. It was not necessarily the booking that led to the harm. However, it was the incidents that occurred within Italy itself. Turning back to the card member agreement, that agreement governs the relationship between Mr. St. Clair and Amex Canada. It regulates such matters such as credit services, payment mechanisms, and concierge access, as described at paragraphs 105 to 107 of St. Clair. Critically, it does not regulate or even contemplate the operations of the water taxis, maritime navigation, or transportation safely in Italy. The duties alleged against Venezia Turismo and the Italian defendants arise entirely from foreign tourist conduct namely in the operation and dispatch of the water taxi in Venice. Those duties exist independently of the card member agreement and would apply regardless of how the taxi was booked. The Supreme Court accepted, for analytical purposes only, that the card member agreement may have been formed in Ontario, as noted in paragraphs 9 and 103 of St. Clair. But the court was equally clear that the formation alone is insufficient.
The plaintiffs, the Sinclairs, are arguing that there are implied or implicit terms in their contracts with Amex Canada to hire appropriate agents for their travel experience. Don't we have to accept that allegation on its face at this stage in the proceedings? And if so, doesn't that address your concerns?
In terms of the overall error, it lies in treating the legally irrelevant contract as a jurisdictional grounding. So that becomes an error of principle and not a disagreement of the overall factual findings. It becomes therefore incidental and not foundational to the overall dispute. As Van Breda cautions, a contract is not connected with the dispute simply because it forms part of the factual background or a causal chain.
Well, the submission of your friends have also made an important distinction that this court would ask you to respond to. Your friends have submitted that this is not merely a case of paying for a service with an American Express card. Rather, the entire arrangement of the service was done within the scope of an agreement with American Express, which was made in Ontario. How do you respond to that distinction asserted by your friends?
In terms of the distinction, it does not create a shape or govern the standard of care alleged to have been breached. The duties in issue arise from the operation of the water taxi itself in Italy and exist independently from the overall card member agreement. Regarding our friend's alternative position, the respondent submits that the water taxi reservation cannot be characterized as distinct in an Ontario contract. The Supreme Court expressly rejected that characterization. The reservation was not a standalone agreement formed in Ontario, but merely a performance of the existing card member agreement. There was no negotiation, acceptance, or the meeting of minds in Ontario involving Venezia Turismo. The Italian defendants did not target Ontario, solicit Ontario customers, or enter into any foreign-based contractual relationship.
Well, they didn't have to. They have this arrangement with American Express whereby they receive the customers that are part of this membership agreement.
Yes, Justice, that is correct. However, the Italian defendants did not solicit the Ontario customers. They did not direct business towards Ontario or enter into any foreign-based contractual relationship, as emphasized in the majority of St. Clair.
But the Amex concierge service held itself out as being able to provide a high quality and safe travel experience.
In terms of their claim over there, they can expect to get sued, but only within the relationship to where it carries on its operations. That expectation does not extend to being sued within every customer's home jurisdiction simply because of the customer being resided within that location. To hold otherwise would permit Ontario courts to assume authority over foreign defendants based on nothing more than the location of the credit card transaction. That result would undermine the principles of order and fairness that lie at the core of the real and substantial connection test.
Counsel, if I understand your submissions before this court correctly, you're not denying that Venezia Turismo could be subject to legal action. All you're saying is that that legal action needs to be brought before an Italian court. Is that correct?
Justice, what I am trying to pursue is the connection that Ontario has, which is the overall administrative booking step, which did allow for the negligence and the harm that all rooted back to Italy. I see that I'm approaching my time. May I request a brief indulgence?
Absolutely.
In conclusion, honorable justices, No Ontario contract connected to the dispute exists. The American Express card member agreement is too remote to ground jurisdiction. The water taxi reservation is not a separate Ontario contract, but merely a contractual performance. Accordingly, the fourth presumptive connecting factor is not established. Barring any further questions, I will now yield the podium to my co-counsel, Faith Sajid Kumar, to address the second submission on behalf of the respondents.
Thank you.
Of the Supreme Court of the Waterloo Cup. My name is Faith Sajid Kumar, and I appear on behalf of the respondent, Vanessa Turismo. I will be addressing the second submission for the respondent today. As my co-counsel has explained, the respondent's primary position is that no Ontario contract connected with this dispute exists. The respondent will now submit its second submission. Even if this court were to find that a presumptive connecting factor exists, the respondent submits that the presumption of jurisdiction has been rebutted. At the heart of this issue is whether the Ontario has a real and substantial connection to the dispute before the court. Respectfully, it does not.
Counsel, who has the onus of rebutting the presumption?
Justice, we as the respondents have the onus to rebut the jurisdiction.
And can you point me to any evidence that the defendants placed before the motions court judge rebutting the presumption?
Justice, regarding the motion court's judge, they placed before them that the connection to the contract regarding the Amex Canada card member agreement was too weak and incidental to connect back to Ontario and not to Italy.
Okay, but that's the contract argument. Can you point me to any evidence that rebuts the presumption if I side with your friends, the appellants, that there was a contract sufficient to connect the claims to the jurisdiction of Ontario?
Justice, respectfully, at this jurisdictional stage, the evidence that we rely on is primarily the undisputed facts and the framework set out in Vendretta. We're not yet at the point of a detailed trial evidence. Instead, we are pointing to the agreed facts. Accident happened entirely in Italy. The defendants are Italian entities, and they don't do business in Ontario. Our position is that these facts are enough to rebut jurisdiction at this stage.
It's not that simple. This court agrees with you that they don't do business in Ontario. That I don't think is in dispute. Where it becomes difficult, and we want your submissions on how to clarify, is what happens when they conduct business with customers that come to them through Ontario contracts. No one is saying that they went and approached the St. Clairs, but we have to acknowledge how the St. Clairs ended up on that boat. They didn't find it themselves. They went through American Express because they had a contract, and that contract is from Ontario.
Justice, even if we agree that the contract is from Ontario, that is not enough to place jurisdiction in Ontario. Repeated once again, the Vendretta has a two-stage analysis. In the second stage, we are trying to establish a real and substantial connecting factor towards the contract made, and we rebut that it is a weak and incidental contract.
Okay, counsel, but if an Ontario contract is being performed and executed abroad, does that not within itself create jurisdiction?
Justice, respectfully, it does not. That is not simply enough to create jurisdiction because the defendants are in Italy. The accident happened in Italy, the tort occurred in Italy, and so as such, the Ontario contract, even if we agree that it was the initiator or for the chain of events, it is not enough to ground jurisdiction, Justice.
But counsel, if I decide that I want to go on an Italian holiday with my wife, and I see an advertisement from an Ontario company that says they're going to provide flights and hotels and transfers and meals and all of the incidentals that relate to my trip to Italy, if I accept that contract and enter into that contract with the Ontario company, and something unforeseen happens on my Ontario trip, can't I sue them in Ontario? And isn't that what happened in this case effectively?
Justice, respectfully, in this case, the Sinclairs specifically had the contract with Amex Canada, and as such, they had the initial contract in Canada. In Ontario, Canada.
Yes.
However, the entire tort once again occurred in Italy, and yes, you may say that Italy can expect to get sued by travelers that are expecting safe care in their services. However, they can only expect to be sued in relation to where it carries on its operation. In this case, Italy. That expectation does not extend to being sued in every customer's home jurisdiction simply because the customer resides there.
But aren't we denying access to justice to this poor Sinclair family who've had a catastrophic injury happen to them on this Italian trip if we don't assume jurisdiction here in Ontario?
Justice, we're not denying them justice in this case. We are simply asking for jurisdiction to be placed where it rightfully deserves to be placed. And in this case, it is Italy, because the Ontario contract is not enough to establish jurisdiction simply because it was the initiator for the chain of events. When the court examines the substance of this dispute, every material points decisively to Italy. The accident occurred on Italian waters. The water taxi was owned by an Italian company, dispatched by an Italian consortium, and operated by an Italian driver. The applicable safety standards, the regulatory framework, the witnesses, and the physical evidences are all located in Italy.
Well, how would you respond to the submissions of your friends that you can't escape contractual obligations simply by hiding behind geography?
Justice, I would respectfully like to say that we are not hiding behind geography, but rather we want the Sinclairs to be able to receive justice in the rightful place. And that is Italy, as that's where the tort occurred. The company was Italian, and once again, that is where they're able to receive justice in Italy. However, at this stage, we are simply looking to see that the connection that the Ontario contract has to the dispute is too weak to justify jurisdiction in Ontario under Vendretta. As mentioned in paragraph 35, to characterize this dispute as being meaningfully connected to Ontario would stretch the concept of justice beyond its principled limits. Those principled limits are grounded in fairness, order, and predictability. They ensure that the courts exercise authority only where it is legitimate to do so, and that the defendants are not required to answer proceedings in jurisdictions with which they have no meaningful legal relationship. The rebuttal stage of the Vendretta analysis exists to protect precisely against that risk. Venezia Turismo does not carry on business in Ontario. It does not advertise in Ontario, solicit Ontario customers, or otherwise take advantage of the benefits and protections afforded under Ontario law. The respondent had no control over where Mr. Sinclair chose to initiate his reservation and could not reasonably foresee being subject to litigation in Ontario as a result. At paragraph 216, this court confirms that rebuttal is established where it would not be reasonable to expect the defendant to answer proceedings in the forum. That threshold is met here. If jurisdiction were assumed on these facts, it would create a dangerous precedent. Any foreign service provider could be brought before an Ontario court simply because a Canadian consumer used a domestic intermediary to arrange services abroad. The majority
Not just a domestic intermediary, but operating within the context of a domestic contract. You'll agree with me that those are slightly different things.
Sure, Justice, I can agree with you that those are slightly different things. However, this does not change the respondent's arguments that, once again, that Ontario contract is too weak to ground jurisdiction in Ontario.
But your friends have stated that it's not just about that contract within itself, it's the totality of events. One thing fed off of the other. It was a chain of events.
Sure, Justice, I can agree that there was a chain of events. However, the majority of the chain of events occurred in Ontario.
Majority happened...
Sorry, in Italy.
Yes, the majority happened in Italy. I think this court agrees with you there. Where we disagree, and I think why the dispute is before us, is that the chain started in Ontario.
Justice, I see that I'm approaching my time. May I have a brief indulgence, please?
Absolutely.
Thank you. So, even if the starting point was in Ontario, the tort occurred in Italy, and thus everything should be.
Council, I know that your time is elapsing, but I really just want to drive this point home. What relevance is the location of the tort if the contract itself was formed in Ontario?
Justice, the relevance that the contract has, we believe, is weak and insufficient, right?
No, what relevance is the location of the tort, as you just mentioned?
The location of the tort will allow the Sinclairs to be able to receive justice in a place where the Italian defendants are located in Italy, right? The consortium in Italy. So they were able to receive justice under Italian law where the tort occurred, under which the driver was operating under. I yield my time now these are the respondent submissions. Thank you.
Thank you very much, Council, for your very thoughtful.
Hi everyone. Okay, so we've come to a decision on who is our Waterloo Cup champion. First, we're going to announce our semi-finalists and welcome you up for your medals. So we have Team 7, Kedar and Prarthi. And then we have, as our other semi-finalists, Team 4, Juliana Tovar and Madison Lennox. Okay, so now we are going to announce the champions of Waterloo Cup. Can we get a drum roll, please? The champions of Waterloo Cup will be Team 1, Ethan Gova and Sylvia Trecki.
Thank you very much.
Congratulations. Photos, people.
Okay. And that means the finalists of Waterloo Cup is Faith and Benisika.
Congratulations to you both.
To begin my final words, at the very end of this, I'm going to ask all of our amazing winners to come up and pose in front of our wonderful banner so we can get more photos of you guys. So to conclude the Waterloo Cup, I want to sincerely thank our judges for coming out this weekend and giving us their time, and also battling the horrible weather and ice outside and trying to find QNC, which is a kind of tricky building to find. I want to thank our amazing competitors. I saw a lot of talent today, and I'm excited to continue working with you guys. If you are interested with continuing mooting with us and you had fun today and you want to go to Osgood Hall, you should try out for the competitive team, which opens up tryouts next week. Check our Instagram page for the booking link. I think you should all come because I am insanely impressed with the talent I saw.
Anybody who competed today should be automatically qualified, right?
Yes. And I also want to thank my amazing executive team for coming out both days and helping me and Nicolette pull this competition together, getting food and all of it. And a special thank you to Nicolette. This was her baby. She organized, picked the case, made the competitors package, and emailed all of you. So big round of applause for Nicolette.
And on my behalf, thank you for everyone who showed up. And I'm just really proud to announce that this was our first Waterloo versus Waterloo final, which is outstanding. And the fact that all of you advanced is amazing. And I'm really proud of all of you for, coming up with all of this after like weeks and weeks of practices. And you guys have demonstrated so much growth and learning. Thank you so much to my entire executive team. Thank you so much, Eliza, for putting up with all the craziness in the past few weeks, and for all of you guys for remaining so adaptable. For those of you who don't know, it is Eliza and I's last term on UW Moot, so this is also our last cup. And time at UW. Thank you so much to all of our judges who took the time out of your weekend to come up and judge our little event. It always means a lot. And finally, thank you to our competitors and everyone else who attended. So, barring any further questions, this concludes the Waterloo Cup.